The treaty establishing a constitution for Europe was an unratified international treaty intended to create a consolidated constitution for the European Union. It would have replaced the existing European Union treaties with a single text, given legal force to the Charter of Fundamental Rights, and expanded qualified majority voting into policy areas which had previously been decided by unanimity among member states. The treaty was signed on 29 October 2004 by representatives of the then 25 member states of the European Union. It was later ratified by 18 member states, which included referendums endorsing it in Spain and Luxembourg. However, the rejection of the document by French and Dutch voters in May and June 2005 brought the ratification process to an end. Following a period of reflection, the Treaty of Lisbon was created to replace the Constitutional Treaty. This contained many of the changes that were originally placed in the Constitutional Treaty but was formulated as amendments to the existing treaties. Signed on 13 December 2007, the Lisbon Treaty entered into force on 1 December 2009. History. The drafting for European Constitution began in a call for a new debate on the future of Europe at the Laeken European Council in December 2001. A European Convention was founded shortly afterward, which was chaired by former French President Valéry Giscard d'Estaing and composed of 2 members of parliament of each member state and applicant state. 16 MEPs, 2 members of the European Commission and a representative from each government. It met in public. Giscard d'Estaing proposed to draft a constitution. Romano Prodi, the president of the European Commission, backed a draft text called Penelope Project, which contained a deeper integration of the countries and a more clear institutional model. After protracted negotiations in the Intergovernmental Conference during the Italian presidency, disputes arose over the proposed framework for qualified majority voting. The final text of the TCE was settled in June 2004 under the Irish presidency. Signing the treaty establishing a constitution for Europe was signed in Rome on 29 October 2004 by 53 senior political figures from the 25 member states of the European Union. In most cases, heads of state designated plenipotentiaries to sign the treaty. But some presidents also signed on behalf of states which were republics. Most designated plenipotentiaries were prime ministers and foreign ministers. Ratification. On 12 January 2005, the European Parliament voted a legally non-binding resolution in support of the Constitution by 500 votes in favour, to 137 votes against, with 40 abstentions. Before an EU treaty can enter into force, it must be ratified by all member states. Ratification takes different forms in each country, depending on its traditions, constitutional arrangements and political processes. Most member states ratify EU treaties following parliamentary votes, while some, notably Ireland and Denmark, sometimes hold referendums. As a reaction to what was seen as the novel nature of the Constitution, many advocates and opponents of the Constitution argued that it should be subjected to referendums across the European Union. On 20 April 2004, then British Prime Minister Tony Blair unexpectedly announced an intention to hold a referendum, a proposal which he had previously rejected. A further 7 member states announced or had already announced that they would hold referendums on the Constitution, these being Denmark, France, Ireland, Luxembourg, the Netherlands, Spain and Portugal. Spain was the first country to hold a referendum on the Constitution. On 20 February 2005, Spanish voters backed the treaty with 76% voting in favor to 24% against, on a turnout of 43%. On 29 May 2005, the French public rejected the Constitution by a margin of 55% to 45% on a turnout of 69%. Just 3 days later, the Dutch rejected the constitution by a margin of 61% to 39% on a turnout of 62%. Notwithstanding the rejection in France and the Netherlands, Luxembourg held a referendum on 10 July 2005 approving the constitution by 57% to 43%. It was the last referendum to be held on the constitution, as all of the other member states that had proposed to hold referendums cancelled them. Post-rejection after the French and Dutch referendum results, European leaders decided to hold a period of reflection on what to do next. As part of this reflection period, a group of wise men was set up to consider possible courses of action. This group of high-level European politicians, former prime ministers, and members of the European Commission, first met on 30 September 2006 in Rome. On 4 June 2007, this group, known as the Amato Group, presented its report. They proposed to establish a new intergovernmental conference with a view to writing a new treaty which would rewrite the Maastricht Treaty, amend the Treaty of Rome, and give the Charter of Fundamental Rights of the European Union a legally binding status. The new treaty would be based on the first and fourth parts of the Constitution, the rest of the Constitution's changes being achieved through amendments to the Treaty of Rome. In the June 2007 European Summit meeting, member states agreed to abandon the Constitution and to amend the existing treaties, which would remain in force. They also agreed a detailed mandate for a new intergovernmental conference to negotiate a new treaty containing such amendments to the existing treaties. These negotiations were completed by the end of the year. The new treaty, which had previously been referred to as the Reform Treaty, became the Lisbon Treaty on its signing in Lisbon on 13 December 2007. National processes at a glance. Content. Institutional structure. Or under the TCE, the Council of the European Union would have been formally renamed the Council of Ministers, which is already its informal title. The General Affairs Council would have been formally split from the Foreign Affairs Council, which had informally held meetings separately since June 2002. The TCE proposed the formal recognition of a flag, an anthem and a motto for the Union, although none of them were new. Conferral, subsidiarity, proportionality. The TCE would have reiterated several key principles of how the Union functions. The principle of conferral, that all EU competences are conferred on it voluntarily by member states. The principle of subsidiarity, that governmental decisions should be taken at the lowest level possible while still remaining effective. The principle of proportionality, that the EU may only act to exactly the extent that is needed to achieve its objectives. The primacy of EU law. The TCE would have specified that the EU is a union of member states, and that all its competences are voluntarily conferred on it by its member states according to the principle of conferral. The EU would have no competences by right, and thus any areas of policy not explicitly specified in the Constitution would have remained the domain of the sovereign member states. According to the TCE, the EU may act only where its member states agree unanimously that actions by individual countries would be insufficient. This is the principle of subsidiarity, and is based on the legal and political principle that governmental decisions should be taken as close to the people as possible while still remaining effective. It is a main argument against claims that Europe limits national sovereignty, but critics say that it is a principle to which lip service only is paid, and, in practice, the reach of the EU has been increasingly ambitious. Primacy of Union law amongst European countries. The European Court of Justice has consistently ruled since 1964 that EU law has primacy over the laws of member states in the areas where member states allow it to legislate. National law which is incompatible with an agreement already made at European level is deemed to be disapplied when questions arise in courts. This controversial and fundamental principle of European community law was first recognized in the case of Luz in 1963, which was followed in Costa v. Enel in 1964. Common values of the Union's member states is stated in Articles I1 and I2. The Union is open to all European states that respect the member states' common values, namely, human dignity, freedom, democracy, equality, the rule of law, respect for human rights, minority rights, free market. Member states also declare that the following principles prevail in their society: pluralism, non-discrimination, tolerance, justice, solidarity, equality of the sexes. Some of these provisions would have been codified for the first time in the TCE. Aims of the Union. The aims of the EU were stated to be promotion of peace, its values and the well-being of its people, maintenance of freedom, security and justice without internal borders, and an internal market where competition is free and undistorted, sustainable development based on balanced economic growth and price stability, a highly competitive social market economy, social justice and protection, equality between women and men, solidarity between generations and protection of the rights of the child, economic, social and territorial cohesion, and solidarity among member states, respect for linguistic and cultural diversity. In its relations with the wider world, the Union's objectives are to uphold and promote its values and interests, to contribute to peace, security, the sustainable development of the earth, solidarity and mutual respect among people, free and fair trade, eradication of poverty and the protection of human rights, in particular the rights of the child, strict observance and development of international law, including respect for the principles of the United Nations Charter. Scope of the Union competences. The EU has 6 exclusive competences. Policy areas in which member states have agreed that they should act exclusively through the EU and not legislate at a national level. The list remains unchanged from the previous treaties. Customs Union. Those competition rules that govern the internal market. Eurozone monetary policy. Conservation of marine biological resources. Common commercial policy. The conclusion of certain limited international agreements. There are a number of shared competences. These are areas in which member states agree to act individually only where they have not already acted through the EU, or where the EU has ceased to act. 3 new competences have been added to those in previous treaties. There are a number of areas where the EU may take only supporting, coordinating or complementary action. In these areas, member states do not confer any competences on the Union, but they agree to act through the Union in order to support their work at national level. Again, 3 new competences have been added to those from previous treaties. Flexibility clause. The TCE's flexibility clause allows the EU to act in areas not made explicit in the TCE, but only if all member states agree, with the consent of the European Parliament, and where this is necessary to achieve an agreed objective under the TCE. This clause has been present in EU law since the original Treaty of Rome, which established the EEC in 1958. Common foreign and security policy. The EU is charged with defining and implementing a common foreign and security policy in due time. The wording of this article is taken from the existing Treaty on European Union.